Occupational stress and cardiac ERISA disability insurance claims. Now, I'm often asked, does a disability carrier have to consider the impact of occupational stress on heart conditions in determining whether a policyholder or a plan beneficiary can do the duties of their own occupation? And the general answer is yes. But the real question in my mind is, how does the disability carrier or plan have to go about considering the impact of occupational stress? Now, I will tell you that the first thing the disability carrier has to do is to determine what your occupation was, as that term is defined in your policy or plan. So let me give you an example. I'm going to give you a real-life example found in the case of Leaf versus Hartford. Leaf had a plan that defined her occupation as your occupation is recognized in the general workplace. It doesn't mean your occupation as performed for a specific employer at a specific location. And that was the starting point in this case, and in any case for the analysis. Now, she was employed as a collection representative. Obviously, that's pretty darn stressful because you're on the phone with people who are not happy about collection calls. But it's a sedentary job, and the issue ultimately is what impact does that stress have on her ability to do a sedentary collections position? Now, she alleged that the stress, the occupational stress, increased her cardiological symptoms, and she was unable to perform her duties. Hartford, on the other hand, said, no, we don't think so. Despite your cardiological issues, we think that you're capable of performing your own occupation. And obviously, Leaf appealed and argued that Hartford had improperly focused on whether she could perform any sedentary occupation rather than considering the impact of occupational stress on her heart. Now, as part of her appeal, what she did was she submitted a document. And that document was from the Occupational Information Network that explained that her job duties of a collection representative and the level of stress. So it discussed generally the level of stress of a collection representative that they encountered while doing their job. Now, notwithstanding that fact, and the fact that her physicians expressed concern about the stress that she would encounter and how it increased her symptoms, Hartford continued to maintain its denial. And ultimately, of course, this case ends up in federal court. So what did the judge do, and why, in my opinion, were they wrong? I just gave you a hint as to what they did. The federal judge noted that Hartford had considered the occupational analysis that addressed not only the physical duties of her occupation, but they had considered the journal articles that she had submitted as part of her appeal regarding the correlation between stress and cardiovascular disease. And in upholding the denial, the judge noted that while the judge was sympathetic to the potential role that stress might have in exacerbating her cardiac condition, in the judge's view, the case turned on whether Leaf had met her burden of showing that the cardiac issues prevented her from performing the essential duties of her occupation in the general workplace. Now, to me, that was the issue. And by that I mean, does stress, as collection work is performed across the United States, impact cardiological symptoms? And in my view, stress is stress, and stress is stress across the United States. It doesn't differ from stress in California or stress in New York. It's baked into the occupational duties. Now, the judge reasoned that while the physician's opinion that stress was inconsistent with optimal treatment and that working would exacerbate her symptoms, that didn't, in the judge's view, establish that stress would restrict her from working in the occupation in general. No, I don't agree with that. I think there's a big gap here in the legal reasoning. So the question is, does the occupation as performed in the general workplace involve occupational stress? The answer is yes. The next question is the policyholder disabled because of the impact of stress on the cardiac condition as her occupation is performed across the United States? And obviously the answer to that is yes. So you can see I disagree with the judge's decision. Now, obviously, judges take different approaches depending on the judge, but what impacted, I think, the court's analysis was their misapprehension of the definition of occupation and, unfortunately, giving short shrift to the stress argument. If you have any questions about your rights to ERISA disability benefits, if you disagree with a disability carrier's denial or termination, Call me today at 727-894-3188 for a complimentary consultation. We'll have 180 days in which to file an appeal that can make or break your claim. Call me today, 727-894-3188.